Welcome to Leadership Deep Dive, where we look beyond the headline to examine the systems, decisions, and leadership judgment underneath it. I am your host, Frenetta Tate. Today, we're looking at Buc-ee's and its trademark lawsuit against Beaver's Mini Mart, a small convenience store in Beavercreek, Ohio. Now, I want to be clear about something from the beginning. This is not about whether Buc-ee's has the legal right to protect its trademark. Companies absolutely have a responsibility to protect their intellectual property. What interests me is the leadership question beneath the legal one. Because sometimes the question isn't simply, can we do this? The more important question is, should we do this? And when a company as large and recognizable as Buc-ee's takes legal action against a small neighborhood store, that decision doesn't happen in isolation. It creates reactions, it shapes perception, and ultimately, it can affect the very brand the organization is trying to protect. So today, I want to go deeper. When does protecting the brand begin putting the brand at risk? So, what happened? On July 28th, Buc-ee's filed a federal trademark lawsuit against Beaver's Mini Mart, a small convenience store in Beavercreek, Ohio. Buc-ee's argues that the store's smiling cartoon beaver, red lettering, and other branding are similar enough to its own trademarks that consumers could believe the businesses are connected. The company is asking the court to stop the store from using the disputed branding, and they're seeking other relief. But Beaver's Mini Mart says its signage has been there since 2019, years before Buc-ee's opened its first Ohio location nearby. And that is where the trademark dispute became something much bigger. The basic allegations and requested relief are documented in reporting on the July 28th complaint. Now, the legal question: protecting intellectual property versus the likelihood of consumer confusion. Now, before we turn Buc-ee's into the villain of this story, there is another side. Companies have legitimate reasons to protect their intellectual property. Buc-ee's has invested decades and significant resources building recognition around its brand. And Buc-ee says this dispute isn't simply about somebody using a beaver in a town called Beavercreek. The company says it became concerned about the business's registered Ohio trade name and the possibility of expansion. Buc-ee's also says it attempted to contact the owner before filing suit. Those facts matter because good leadership analysis requires us to understand the decision before we critique it. Today's reporting clarifies Buc-ee's explanation and the distinction between an Ohio trade name registration and the previously reported federal trademark application. But it's important we can shift from can we to should we. And here is where the legal analysis and the leadership analysis begin to separate. The legal team has to ask, can we protect this trademark? And then leadership has to ask something larger. Should we take this particular action in this particular way against this particular business at this particular moment? Those are not the same question. And organizations get themselves into trouble when legal authority becomes a substitute for organizational judgment. Scale changes perception. Buc-ee's is a major, highly recognizable company. Beaver's Mini Mart is a neighborhood convenience store. That difference doesn't determine who is legally right, but it absolutely affects how people interpret the conflict. People aren't only looking at two logos, they're looking at power. And once stakeholders perceive a dispute as a powerful organization using its resources against someone significantly smaller, leadership is dealing with something the courtroom cannot resolve by itself: trust. And this is where I think the story becomes particularly instructive for leaders. Every organizational action creates a second order effect. The lawsuit generated attention, the attention generated community reaction, the reaction generated national coverage. Local residents and businesses began rallying around Beaver's Mini Mart. And John Oliver, who had already criticized Buc-ee's trademark enforcement practices, announced that his parody Buc-off store would remain open as long as this lawsuit continues. So now an action designed to protect the brand has become a national conversation about the behavior of the brand. That is the second order consequence. The local backlash and extension of Oliver's parody campaign are now part of the developing story. And this gives us the leadership equation underneath this entire story. A legal right does not automatically equal organizational wisdom. An organization can be legally justified and still make a strategically expensive decision. That's why leadership judgment has to sit between authority and action. Because authority plus action without sufficient judgment can create reputational risk. And reputation is an organizational asset too. Imagine if these five questions were built into consequential organizational decisions. What exactly are we protecting? How significant is the actual threat? Is our response proportional to that threat? And what could our response cost us beyond this immediate issue? And when this is over, what will our stakeholders believe about us? Notice that none of these questions say don't act. Sometimes organizations absolutely need to defend themselves. The discipline is making sure the response protects the whole institution, not one asset at the expense of another. And that may be the biggest lesson here. Your trademark is part of your brand. It is not the entirety of your brand. Your brand also lives in customer experience. It lives in reputation. It lives in community relationships. It lives in stories people tell about your organization when you're not controlling the message. Buc-ee's may ultimately prove that its trademark rights were threatened. That is for the legal process to determine. But leadership has another responsibility: protecting the institution around the trademark. There is already a separate Buc-ee's trademark case pending in Ohio involving Mickey's and its moose mascot, illustrating that the Beaver's Mini Mart dispute sits within a broader enforcement strategies rather than being an entirely isolated decision. What are we trying to protect? We could, and could the way we protect it cost us more than the threat itself? So I'm not going to tell you that Buc-ee shouldn't protect its intellectual property. That's too easy. The more important question for leaders is this: what are we trying to protect? And could the way we protect it ultimately cost us more than the threat itself? Because leadership isn't only revealed by the decisions we make, it's revealed by what we considered before we made them. There may eventually be a legal answer to this dispute, but the leadership question is bigger than who wins the lawsuit. Organizations makes decisions every day that they have the authority, the policy, the contract, and the legal right to make. But leadership requires another layer of judgment. What are we actually trying to protect? Is our response proportional to the threat? And could the way we protect something ultimately cost us more than the threat itself? Those are great questions to ask because your brand is more than your trademark. I'm Frenetta Tate, and this has been Leadership Deep Dive. The next time your organization asks, can we? Make sure someone is in the room who also is willing to ask, should we? That's the Leadership Deep Dive. If this video resonated and you want to go deeper, visit my website. If your organization is navigating this type of challenge right now, let's talk. Thank you for joining, and I'll see you next time.